Coolidge was in fact held in contempt for the third time. Makeup parenting time was offered or was ordered. Since the filing of this motion, again, Ms. Coolidge has continued to deny parenting time. We're asking for criminal contempt of court for Ms. Coolidge.
The new allegations are that defendant's wife is abusing the minor child. Both her and my client's ex-wife are best friends and are always trying to gang up on my client via lawfare, both here and in Branch County.
I would like my oldest to actually be away from my mom and my stepdad, just because they do a lot of manipulating that is based on around money. And yeah.
This case revolves around a large amount of debt, Your Honor. We're talking hundreds of thousands of dollars here.
Mom has a significant drug history, and that's why her parenting rights are effectively suspended under the current order.
Samantha Coolidge versus Jared Hinkey.
Court on the defendant's motion to show cause for denial of parenting time. I've read all the pleadings. I have not received anything from Mr. Bland, so I don't know what Mr. Bland's position is, but Ms. Henderson, you don't need to reiterate your motion. Go ahead.
Thank you, Your Honor. Your Honor, since the time that we filed the motion, we actually did receive the ruling of referee Snyder following one of our motion hearings. Ms. Coolidge was in fact held in contempt for the third time. Makeup parenting time was offered or was ordered. Since the filing of this motion, again, Ms. Coolidge has continued to deny parenting time, and there were three occasions on which my client or his mother or his fiance appeared to pick up the child, and Ms. Coolidge was not there to turn the child over on Thursday at 9 a.m. as was ordered. So there were three additional instances of denial of parenting time, and it does not appear that Ms. Coolidge is planning to follow the court order whatsoever. In his findings, referee Snyder did observe the not credible enough information about the counselor. The counselor was not there to testify. The motion that was filed to change parenting time sat there without a notice of hearing for a long time. So again, Your Honor, there is nothing in the record that would justify Ms. Coolidge denying my client parenting time. At this point, we're asking for an in-person evidentiary hearing. We're asking for criminal contempt of court for Ms. Coolidge, and we're asking again for makeup parenting time and attorney's fees due to bad faith on behalf of Ms. Coolidge and denying that parenting time, Your Honor. Your Honor, I apologize. I'm having a really hard time hearing you. Is that just me?
No, me too. I was going to ask the judge to repeat himself. I'm very sorry, Judge. You're a little muffled to me.
Okay, well, we're having some difficulties.
Now it's better.
Okay, well, maybe I just need to speak up. I don't know. Mr. Bland, are you looking at an evidentiary hearing in this matter?
Yes, Your Honor. I did file a motion also to modify parenting time. I filed it in July, and I thought it was noticed for today. I don't want to get into the particulars. That's not important to me at this point. But I would, in fact, I think Ms. Henderson answered it. I would just ask if we have a hearing that be noticed for the same hearing. I don't have to go through this process to get that done, Judge, if that would be okay with you.
That would be fine. But Ms. Henderson will address his motion as well at the evidentiary hearing, and we will have that in person. So when we send out the notice, it'll say in person. Make sure that your clients are aware that they have to appear in person.
Thank you, Your Honor.
Yes, Your Honor. Thank you very much.
Okay, thank you. Have a good day.
No,
Thank you.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. White on behalf of the defendant. The court on the defendant's objection to the ex parte order suspending parenting. Ms. White.
Your Honor, is your volume down? I don't know about Mr. Schaefer. I'm having a hard time hearing you.
I agree.
Yeah.
I am also.
I did note in the pleadings there was some involvement by CPS. What is happening with regard to CPS?
Your Honor, as far as I know, they have not completed their report. At least I haven't received anything back from them at this point in time.
Ms. White, is that any different from your standpoint? Have you heard anything?
No, I've received nothing formal, Your Honor.
Okay, go ahead, Ms. White.
Thank you, Your Honor. We finished several days, Your Honor, of an evidentiary hearing at the front of the court over the last year and a half on Ms. Herman's change of custody motion that she filed in November of 2022. At that time, she'd withheld the child and had to give him back when she couldn't get an ex parte motion that facilitated that round. At a hearing on June 10th, we were here on her objection to the front of the court recommendation that denied her motion for a change of custody. And I wasn't served the hearing information and objection to that recommendation that was filed with the court. I had to serve myself notice of the hearing, if you will, by checking the register of actions. The court directed plaintiff to serve me the documents and for plaintiff to order the remaining hearing transcripts for her objection. There was no order filed for that hearing, and I've been served nothing but the ex parte motion and ex parte order. So I wanted to note that first. Ms. Herman then turned around and filed this ex parte motion to suspend parenting time instead. The first ex parte motion were based on allegations in part that defendant's wife was physically abusing the minor child. The new allegations are that defendant's wife is abusing the minor child. Because she had to return the child and lost the last litigation to change custody, now she's not only filed this ex parte motion, but she also filed for a PPO as next friend of the minor child against defendant's wife to make sure he can't be returned home after this hearing. What I find telling is that she first doesn't ask for a motion to prohibit any corporal punishment of the minor child. Neither motion. She first asked for a change of custody and then she asked to suspend defendant's parenting time instead. Both her and my client's ex-wife are best friends and are always trying to gang up on my client via lawfare, both here and in Branch County. She's also already changed the child's pediatrician without the consent of my client, and his pediatrician's office was right around the corner from her home. Our understanding is that she also works midnights. We have no idea who the child is actually staying with. My client and his wife deny these allegations. I also want to note that the minor child may have to testify consistent with Sermon v. Sermon. If pursuant to MCR 3.210 C1 and 8, we request an evidentiary hearing within 56 days and we request attorney fees based on the outcome. And we request that plaintiff's parenting time be suspended so that she'll stop influencing the minor child to benefit her warfare with defendant. We have no problem, Your Honor, stipulating to an order that prohibits corporal punishment by defendant, and that defendant will not allow any third parties to use corporal punishment on the minor child. There's a motion to terminate the PPO set for September 16th, but I'm asking the court to set that aside in deference of this order if Your Honor entered that PPO. I cannot tell on the order itself, Your Honor, whether that's your signature. I don't know if that's you or a different judge that was assigned that PPO. I have the case number if you need it.
Okay. So it sounds like from what you said that you're looking at having an evidentiary hearing. Is that correct?
Yes, if the court doesn't want to dismiss it, but we have contested facts. So under the court rule 3.210 C8, obviously the court, I know this court will most likely have that evidentiary hearing because we do have contested facts, but I'll leave that up to the court's discretion.
Okay. Well, I think Mr. Schaefer, are you looking for an evidentiary hearing in this matter?
Well, that probably is what's going to happen. My client has received the child on the 26th of July with hematomas on the head. The child was taken to the hospital. That was confirmed. There was abuse to the child, and the child relates how he obtained that, and thus the CPS investigation took place. The child, we submitted pictures of the child. If they are suggesting that this is proper treatment of the child, then that's problematical in itself. So I think an evidentiary hearing has to be set.
Okay. What the court will set an evidentiary hearing in this particular matter. And hopefully, I would assume we'd have something from CPS by that time as well on their investigation. And then we'll proceed at that time. We'll be in touch with your offices to see when you're available and we can set that hearing up.
Okay, so is the ex parte order, Your Honor, going to remain in place pending further proceedings?
The ex parte order will remain until the evidentiary hearing. I will tell the parties that, again, should the court find no basis for this, the court would order make up parenting time and make up all of the time that has been, again, denied.
Okay, I'm gonna include that in the order, Your Honor, if that would
That's
be
fine.
permissible. Okay,
Okay, thank you.
okay, thank you. Malcolm, I will call you. I can't hear you.
You're free to go. Have a good day.
Okay,
Okay,
thank
Your
you.
Honor.
This is the third party's motion for temporary custody. Mr. Hauser.
Yes, thank you, Your Honor. Yeah, so in addition to the motion filed, the primary concern here is for roughly 4.5 years before the filing of this motion, the two minor children in this case resided with Miss Kelly Hadler and Miss Brenda Shero at her home. During that time, Miss Shero served as the primary care provider for the children. Roughly around the 4th of July weekend of 2024, Miss Hadler had left the home. Her current location is unknown. At that time, Mr. Lettler came and picked up one of the kids, but not the other child, stating that she lived with him now. Since that time, Miss Shero has not had any contact with the child that Mr. Lettler has taken. Both children are supposed to start at the Harper Creek schools today. The minor child who is in the care and custody of Miss Shero is in school today. Whether or not the other child is unknown. My understanding in reviewing the Register of Actions in this case, there is no custody order, but there is a parenting time and a support order that this honorable court put out back in 2020. And it's also my understanding that there is an active warrant for Ms. Hadler from the 10th District Court.
Okay.
So the request would be, as the minor children resided with Ms. Shero and her husband of 19 years before July 4th, we would ask for a temporary custody order allowing the children to remain with Ms. Shero until we can figure out a permanent custody order and what is going on with mom and dad.
Okay, thank you. Ms. Holder, what's your response?
Please unmute.
All right. My youngest is going to be going to school. Hi.
Okay, you're Ms. Holder?
Yes.
Okay, go ahead.
My youngest is going to be going to school while she's living with her dad. My mom refuses to talk to me. Like, we don't communicate well. So I have been trying my best to work with their dad, and my youngest stays with him because that is the best environment for her at the moment. There's a lot I could go into, but just take it from me that she's better there. And I would like my oldest to actually be away from my mom and my stepdad, just because they do a lot of manipulating that is based on around money. And yeah, it's hard to communicate with my mom in general. So if she has both of my kids, I know that she's going to keep them and try to exploit them in ways that that's why I left, was because she was doing it to me and my kids.
Okay.
I left to be able to find work and things like that, and I just haven't done it yet. I have a lot that I got to take care of first. And the warrant, I have served my warrant, and I'm actually in therapy and everything and taking care of that. I have a court date coming up.
Okay, thank you. Mr. Leiter, what's your position?
I agree with Kelly on all of those points. I do have Mila. She is scheduled to start. We live in Springfield here, and she's scheduled to start Wednesday school, Valley View. Everything's taken care of as far as that goes. I would like to have full custody of both my kids, both of them.
Okay. Well, what the court's going to do in this matter is parenting time is governed by MCL 722.27B. There are requirements under the statute for grandparents to have parenting time. Again, that would overcome the parental presumption that exists under the statute. So that's going to require an evidentiary hearing where we're going to have to take testimony from all the parties and establish whether, again, the children are basically at a substantial risk of mental, physical, or emotional harm if they're in the care of the grandparents. So the court will set this matter for an evidentiary hearing, and we'll have a hearing and take testimony and evidence at that time to see if it satisfies the basis of the statute. So with that, we will be in touch with you about setting up a hearing date.
Your Honor,
Yes,
might I ask, I can still keep Mila with me, correct, until that time?
I'm not gonna pass on that. I have not done anything as it relates to custody.
Okay.
In fact, there is no custody order.
No, I have full custody.
Okay, well,
I've never lost custody.
okay, regardless, I'm not changing an order until we have an evidentiary hearing.
Right, okay, no, I get that. Can I, if it's okay by me, can my oldest go to her dad's? Like, could he?
Ma'am, I can't give you legal advice. All I can say is that the orders that are in place will remain in place until we have an evidentiary hearing.
Okay, that's, okay,
Okay?
yeah, thank you.
We will be in touch with you and set up a hearing date. Way to go. You can have a good day.
Thank you very much, Your Honor.
This matter is before the court on the defendant's motion for custody and parenting time. Ms. Yancey.
Thank you, Your Honor. As indicative of our motion, the parties were not married. They have one minor child, Silas. And at the time that the child was born, the parties were not together. My client is the legal father. He is on the birth certificate. He signed the affidavit of parentage. I did provide a copy of that with my filing. There is also a child support file with your county. The reason for the delay in filing this in your county, Your Honor, just so you have a history, is my client actually started this proceeding as a child support matter. And he actually filed it in St. Joe County, and then it got transferred to Branch County because the child had been moved there with mother. Then it came back to St. Joe County, and then it went to Calhoun. So we had to wait until somebody took the case and there was an actual filing before we were able to file. The parties have had kind of an on again, off again in terms of relationship with the child, in terms of my client being able to see the child. There was some equal parenting time that was occurring until this got filed. But now recently my client has seen the child 3 times at his home since our filing, and he did have the child from 6 a.m. to 6 p.m. This past Saturday. So my hope is that the parties can work this out and that my client can be awarded joint legal custody so he can be involved in major decision-making with the child, such as the child's medical, where the child will go to school, where the child lives. But we're asking, Your Honor, for at least 50-50 parenting time at this time in custody. My client has stable housing in Sturgis. He lives with his parents. He's always lived there. He is gainfully employed. He has a valid driver's license. He does have a room for the child with a crib. He is able to provide diapers, formula, clothing for the child. He has an appropriate car seat. And he has actually also, and I apologize, he also has had one other visit at a park that the parties met at. So he's been trying to see the child as much as he can. The child's not even a year old, but he does want to be actively involved in the child's life, and he'd like to be able to work things out with mother so that they can co-parent this child.
Okay, thank you. Ms. Trine, what's your response to the motion?
Well, first of all, I have never lived in Branch County. I have only ever lived in St. Joseph County and Calhoun County.
Okay, ma'am, I don't care about all that. The matter is here. We're addressing this today. I don't care about the background of where it was filed, not filed, etc.
Okay. So Landon has had opportunities to see Silas multiple times. There have been a few where he has not wanted to. He has asked me to, and I had set up plans, and he had not shown up or done anything about it. He's not wanted to come here. There have only been there has been 2 times that we have met at parks because the other times he either did not want to come here and it wasn't convenient for me to go all the way closer to him to go to a park or something. And he has seen him 3 times at his house in the past 2 months, I think. But a lot of that is only because he has chosen not to see him anywhere else.
Okay. Ma'am, obviously, it's important that the child have a relationship with both parents.
Of course.
What would you propose for time for Mr. Brumbaugh to see the child?
I would say that the Wednesday every other weekend, or 1 day a week every other weekend, would be fair.
Okay. You say alternating weekend, the standard alternating weekends, Friday at 6:00 PM to Sunday at 6:00 PM. Is that what you're proposing?
Yes.
Okay. And then a Wednesday midweek.
Yes. Or of his choosing,
Okay.
if that's at all possible.
Okay. Ms. Yancey, you've heard the plaintiff. What's your response?
Your Honor, we would propose either a week on, week off, or we would propose a 2-2-3 for the child. That way the child is seeing the parents on a regular basis. My client would have 2 days, mom would have 2 days, and then a parent would have a 3-day weekend. We would like to know where mom's going to be living at. She's in Three Rivers now on the weekends, so that could, the parties obviously have to communicate. Maybe the app close application would be a good application to use for parenting time exchanges and conversations, but we would like to see a 50-50. If not, at least if it is, if Your Honor is inclined to do the midweek, we would at least ask for and at least an overnight on that midweek, and we'd also ask for an extended weekend.
Okay, thank you. Ms. Trine, what's your response to their proposal?
I live in Burlington, Michigan. I have my own house with my sister. I am only in Three Rivers on the weekends occasionally because my cousins live there, and we are pretty good friends, and we go over there often. I would 100% be okay with him spending the night on weekends, of course. On Landon's weekend, he can spend the night from Friday to Sunday. I have no problem with that at all.
Okay.
Midweek, probably I would prefer not an overnight visit, but if push came to shove, I wouldn't mind that either.
Okay. Well, what the court's going to do in this matter is the court's going to grant to the parties on a temporary basis, temporary joint legal custody. The court will grant the parties joint physical custody, which would provide that the defendant would have the child on every weekend from Friday at 6:00 PM to Sunday at 6:00 PM, and then one overnight during the week. We'll set that for Wednesdays if the parties can't agree on another night. If you can agree on another night, being at Tuesday, Wednesday, Thursday, that's fine. But if you can't, then it will be Wednesday night. And the court will set support consistent with that. Ms. Yancey, you can get the income of the parties and calculate the support obligation pursuant to the Michigan Child Support Formula.
Thank you, Your Honor. I'll prepare the order.
Okay, ma'am, you will be getting an order which will recite what we're doing, but the court will order that this take place immediately. So if he can start his midweek on Wednesday of this week, unless the two of you agree upon another overnight, and the weekends that this Friday as well. And court would order that you'd utilize Our Family Wizard or App Close or one of those things, the way you can communicate this way. I will tell both parties that when you communicate through one of those services, those those records are kept of your communication. So the court has access to those. And I only mention it because sometimes people get, unfortunately, very colorful in the language they use. Realize the court will see that in the future if it's necessary.
Your Honor, just for clarifications, on the Wednesday, do we say 6 to 6 then, as we do for the weekend, or what would the court's preference be on that?
That would be fine. We can do it from 6:00 PM on Wednesday or whatever night to 6:00 PM the other night. The parties, it sounds like they're living at a distance. What we'll do is have the parties meet at a halfway point. I don't know what the halfway point is. You'll have to look that up and find out what a halfway point is that you might be able to meet at some public place. You know, I don't know, a particular fast food restaurant that may be at an exit or something of that nature where you can meet.
Okay. Ms. Trine, would Mendon, that would take you on M60 straight here. Would the Mendon Shell or the Mendon Dollar General be okay? He's coming from Sturgis, which is about 25 miles.
The perfect halfway point between me and Landon would be Leonidas. We have both made the drive both ways, so the halfway point is it's 20 minutes both ways. So it's 20 minutes for me, 20 minutes for Landon. It would be Leonidas.
Okay, where would you meet in Leonidas? I've been through Leonidas
There's
a
no,
lot.
yeah, there's no
nothing there.
businesses.
And there's an old store, there's plenty of
There's,
places.
yeah, stores and
Everything's closed. There's no business
plenty of
for
people.
anybody, like if someone, and God forbid, if somebody
Yes.
had to document that they were there and the other party wasn't, there's no way to document a time frame.
Right.
And 35 minutes for you.
Okay, hold on a second. Ma'am, I know somebody's speaking in your background. They're not involved in this proceeding. Tell them they need to remain quiet.
please.
Okay.
Thank you.
I do note in Leonidas, there is a church that's just east of
Yes.
the store area. I do note that they always have a chain up to block off the driveway, but you can pull off the highway there. So why don't we meet at that particular church? And
Okay.
I don't remember the name, if it's Leonidas Baptist Church or what it is.
Yeah,
I think it's a
I'll look
Baptist.
it up, Your Honor. I think it's a Bible church, but I'm not positive either.
Okay,
I'll look it up.
maybe it's a Bible church. I just know it's within a block of the what you'd call the downtown area there.
Yes, I know I know you're speaking of, Your Honor.
Okay, we'll have them meet at that location to exchange the child. If they feel that they need to have a witness, they always have the right to bring a third party present as well.
Okay.
Okay, thank you. You're free to go. Have a good day.
Thank you, Your Honor.
The one party, the mother is deceased. We'll note the appearance of Ms. Reed on behalf of the proposed intervening party. There's also a motion for custody in this matter. Ms. Reed, I guess before I could listen to you, I have no problem. There's no one here to oppose the intervention. The court would grant intervention in this matter. But as you are well aware, in these particular cases, pursuant to MCL 722.27B, the court has to make factual findings as it relates to, again, those factors under the statute in this matter. So what we'll do is the court will set this matter for an evidentiary hearing to address, again, the factors under that statute, which would rebut the fit parent presumption.
Well, this is not a grandparenting time case, Your Honor. This is a custody case by a guardian.
The guardians are grandparents, correct?
No,
Oh, okay. I thought based upon the pleadings that's what.
the guardian is the deceased father's significant other, and she was just recently granted guardianship of the child. And mom has a significant drug history, and that's why her parenting rights are effectively suspended under the current order, because the deceased father was granted sole legal custody, and her parenting time was at the deceased father's discretion. She had to do at least 6 months of drug testing before she had any sort of parenting time.
Okay. I'm sorry, Ms. Reed. I thought that this was, for some reason, I thought that the guardian was a grandparent. So go ahead, Ms. Reed. You can you've given me some more information if there's anything else before we conclude.
It's just as written in our motion, the intervener and the deceased father had primary care and custody of the child for the last 7 years, practically her entire life. The defendant mother hasn't had any contact with the child in the last 7 years. It's the best of our knowledge. She only recently started doing her mandatory drug testing about 6 months ago. And we did appear at the guardianship hearing, and it was represented to us by the defendant mother that she was on board with having parenting time at the discretion of the child's counselor, because the child is going through some significant counseling at the moment because her father just passed, and she's having some additional stress because she's undergoing testing and monitoring due to the trying to see if she has the same medical condition that caused her father's passing. So she's a little stressed out about that as well. And it's going to take some time to reestablish that relationship between the defendant mother and this child, because this child has no idea who this mom is. She knows her name, and that's about it. So we're requesting that the intervener be granted sole legal custody and parenting time to defendant mother at the recommendation of the child's counselor, and my client is not requesting child support.
Okay. Just clarify what relation is the intervener to the child?
She has no familial relationship. She was the decedent's significant other who has lived with the child for the last 7 years.
Okay. Well, what the court will do in this matter is at least obviously the intervener is the guardian of the child, and obviously based upon the facts, the child has been there for a substantial number of years without any involvement of the defendant in this particular case. The court will grant the temporary care to the intervener in this particular matter, and at some point we'll leave that in place. And I guess at this point, Ms. Reed, I'll leave it up to you after a period of time if we think you need to have a evidentiary hearing. I don't know what obviously is going to take place as it relates to any of the other proceedings that have been involved in this matter. So we'll put that in place now, and then you have a right to proceed either for entry of a full order at some later time, or we can modify it based upon whatever happens as it relates to parenting time.
So for language of the order, she's having temporary sole legal custody
Temporary, yes, yep,
and physical custody, and for parenting time is reserved?
yes.
Okay,
And then that way mother can come in and seek parenting time, and we'll have a chance to review any conditions or anything that need to be done in that regard.
all right.
Okay, you can prepare that, submit under 7 day.
Thank you.
Thank you. Have a good day. This matter is before the court on the defendant's motion to modify child support order in this particular matter. Mr. Vanderhorst, did you get Mr. Bartel's answer in this case?
Yes, I did, Your Honor.
Okay, I've read your pleadings. I really appreciate it if you responded to Mr. Bartel's answer rather than just reiterate your motion.
Okay, thank you, Your Honor. Yes, pursuant to Mr. Bartel's motion, just to kind of go back, parties separated on March 1st, 2024, have a 20-year marriage. Plaintiff has typically handled all the parties' finances, and that defendant has had zero access to the parties' financial accounts since the separation. Discovery requests were mailed out 2 weeks ahead of the discovery deadline and were due before mediation. This case revolves around a large amount of debt, Your Honor. We're talking hundreds of thousands of dollars here. Defendant is seeking verification of debt, especially in regards to the loan that the plaintiff received from her father, and is also seeking additional information regarding the party's food truck business. No trial date has been set yet, and the plaintiff would not be prejudiced if she is required to, or if discovery deadline is extended by 30 days. So to properly prepare potentially for a second mediation or a trial date, defendant is requesting that the discovery request be extended by 30 days. I understand Mr. Bartel's position and the court rule on this. So we also have a settlement conference scheduled for March 9. So I was just hoping the court would give us an additional 30 days so we can get information on this to either enter into a settlement or prepare for trial.
So did you have the mediation last week?
We did, Your Honor. I believe we covered a lot of ground. I think we made some progress, and I think my client just to enter into a settlement agreement just needs some additional verification on the debt, the assets involved in this case.
Okay. Mr. Bartel, do you oppose the extension of the deadlines for discovery and maybe perhaps additional mediation?
Yes, Your Honor. They submitted their discovery not pursuant to the court rules. We have submitted actually a thumb drive of thousands of pages of documents, which include tax returns and a lot of the information they're actually requesting in their discovery requests. So it's either they haven't really looked at the what we have provided in the initial disclosures, or they are just doing this to harass my client. Since this court rule is pretty clear as to when you have to submit discovery, we actually followed it. It came to a point at mediation, not getting into all particulars. Defendant, I take issue. He didn't really participate. He said, I'm not doing this until the judge rules on Monday. And so he has all the information. He just wants to harass my client at this point. And if for some reason this court's wanting to allow this, which I think they have 90% of everything actually in front of them, then we would ask for costs for having to deal with this, since they improperly brought this about before the court.
Okay, thank
May I
you.
briefly respond, Your Honor?
Yes, go ahead.
Thank you, Your Honor. We did receive substantial documentation, especially regarding the party's debt. There was information that was not produced that we've specifically requested in our interrogatory request regarding some of the debt and also some insurance money, specifically where that went regarding some assets that the parties have. So defendant did participate in good faith in mediation, so we're trying to either resolve this case or properly prepare for trial. Thank you, Your
Okay.
Honor.
Well, what the court's gonna do, I understand the situation that the discovery request was not timely to allow the plaintiff to respond, but obviously it's important that the parties have opportunity to resolve matters. What the court will do is extend the discovery for approximately 30 days through September 1, 2024, and then order that the parties would engage in additional mediation in September 2024. We'll set a new settlement conference notice for sometime in early October then.
Just one question, Your Honor. So I'm assuming would that push back the witness and exhibit list disclosure? Would that be due after our second
It
mediation?
does not change that because
Does
the
it?
order states that those disclosures are to be made within 21 days after the first mediation date. That's why we put first, so that people don't extend those dates to try to get an advantage under disclosures. So
Understood,
those
Your
will
Honor.
remain in place.
Thank you, Your Honor.
Okay, and Mr. Vanderhorst, you can prepare that order. I will reserve on cost at this time.
Okay, thank you. I will, Your Honor.
Also, Your Honor, I guess, how do we deal with discovery if you're saying September 1st? I mean, are you telling we have to now respond to their discovery by September 1st?
Correct.
Or
Correct. Correct. I understand you don't have any discovery out, Mr. Bartel. Is that correct?
that is correct. I submitted it timely, Your Honor. And I guess, can we just respond in the discovery if we've already provided it, that is sufficient for this court?
Yes, yes. If you provide that discovery, then Mr. Vanderhorst will, again, it's extended, so he'll have to respond to that within that time frame as well.
Thank you, Your Honor.
Thank you.
Thank you.
Have a good day.
You too.
You
Thanks.
too.
Court will note the appearance of Mr. Todd on behalf of plaintiff. Defendant has not appeared, nor has defendant responded. Obviously, it appears that you have some issue with service, and that's why you filed the motion for alternate service. The court will grant your motion for alternate service pursuant to Michigan Court Rule 2.106 in this matter. Mr. Todd, you can submit a order allowing for alternate service, and we will get that signed for you.
Okay, and just put publication?
Yes, yep.
Okay.
Publication pursuant to MCR 2.106.
Got it. Will do.
Charlena Olapod versus Alabala Olapod.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Mr. Rosenthal on behalf of the defendant. This matter is before the court on the defendant's motion to set aside default. Mr. Rosenthal.
Yes, and good morning, Your Honor. May it please the solemn report, Matthew Rosenthal on behalf of Ole Alapate, P number P84807. Yes, Your Honor. When this case was filed, we're asking to set aside the default so we can get to mediation, Your Honor. Right now, my client has made sure to stay in compliance with the order that was rendered prior to our appearance. He did pay the office of Miss Ness $1,500. He also, we have an appraisal that we just got the results from, I believe, yesterday. We also took care of that, Your Honor. I'm sorry we're here for a default. I was under the understanding when this was sent to our office, it was mediation, and that was not the case. I got a consent judgment of divorce, something that was not any answer or not any complaint or anything, just it was like a consent judgment. So I thought we were on our way to mediation because I didn't know. I thought answer and counterclaim were already filed. I did ask my client. He was under the understanding this was on mediation. My wife, I was on paternity leave, Your Honor, and my wife had a hard pregnancy. She's 37. We went through 2 miscarriages and she gave birth on the 6th. I contacted the offices after my paternity leave, your clerk, as well as Miss Neff's office to come to find out, you know, where we were and that they didn't have my information. I don't have any messages from any opposing counsel, nor did my office, from my understanding, have any messages. Right now, Your Honor, we'd ask that this be set aside so we can properly adjudicate it. I think, we are in a good place after talking to opposing counsel. My client does want to make sure his wife is obviously compensated, not just through, whatever equitable divide of the home is or marital share, but anything that may be considered as alimony. He does care about his wife and his child, his 16-year-old, and he wants to make sure it's done properly. And that's where we are today, Your Honor, respectfully.
Thank you. Ms. McNiff, any response?
Your Honor, we did in fact contact Mr. Rosenthal's office. My assistant called the office 4 or 5 times and received no response. But that being said, we have absolutely no opposition to defendant participating in mediation, even with the default in place. In fact, we have mediation set for September 3rd. I'm not sure about the consent judgment. There was a temporary order, and my guess is that maybe is what Mr. Rosenthal is referring to. I believe that we have custody pretty much settled between the parties. So I would suggest we can leave the default in place. We can move forward with the mediation on September 3rd, now that we have the house appraisal and we have exchanged some discovery information with regard to income and that information. I'd like to give mediation a shot on the 3rd, see if we can settle this.
Okay, thank you. Now, what the court will do is I've heard that, I've read the pleadings, I've heard the argument. The court cannot find that there is good cause to set aside default. I will deny the motion to set aside default. However, the court will allow defendant to participate in contested matters, which would mean mediation or trial if it's necessary. Mr. Rosenthal, you can prepare that order consistent with that, and you can attend mediation. Hopefully you get matters resolved.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Megan Forum versus Storm Goodale.
The court will note that this matter is before the court pursuant to the plaintiff's motion to set aside the referee recommended order in this matter. Ms. Gorham, you can proceed.
Yes, I just wanted to object due to the fact that the other party did not provide proof of income such as W-2s or tax returns. So that I just felt there was factual error there. And then the other thing being the case with his daughter is established, and he, when asked about it, I don't believe he was being honest there.
Okay, go ahead, Mr. Goodell.
Okay, I guess I'm not sure why tax forms and all that are being brought up. If that was something that needed to be provided, I could easily do that. So I'm not sure what that's all about. And for my other daughter, Everly, that is something that I'm still in the process of, and nothing has been set. So there was nothing to be dishonest about.
Okay, thank you. Anything else, ma'am?
No.
Okay. Well, the court will state that I did have the transcript available. The court reviewed the entire transcript in this matter. I would note that neither party introduced any exhibits to establish any income or any other facts in the case other than testimony. The referee stated at one point, I think I got all that I need from plaintiff. And I would point out plaintiff did not subpoena the information she's now requesting and did not acquire any discovery in this particular matter. As a result, the court does not find that the referee made any factual or legal error by relying upon the testimony in this case. As a result, the court is going to deny the motion, and that order will remain in full force and effect. You're free to go. Have a good day. Court will note that this matter is before the court on the defendant's motion to set aside default. Ms. Allen, you had alleged you did not realize that you had to put in an answer or how to do so. Is that the basis for your motion to set aside the default?
Yes, I spoke with a woman from legal services that didn't represent me, and the paperwork never came. And so then when Cameron served me the papers, he told me that we would still, it was just part of the process, and that we would meet up with the mediator. That was the next step. And I would say depression probably played a role in it.
Okay. Mr. Allen, any response?
No, sir.
Okay. Well, the court notes in looking at the pleadings and the argument today that what has been alleged by the defendant does not constitute good cause to set aside the default. So the court will deny the motion. However, the court will allow the defendant to participate in contested matters. So, Ms. Allen, what you're going to have to do, because you're the prevailing party in this matter, you'll have to provide an order which states that your motion is denied, but the court has allowed you to participate in contested matters, and you'll need to get that submitted within 7 days of today's date under a notice of entry. Okay?
Okay.
Okay. Thank you. That will conclude the matter. You're free to go. Have a good day.
Refusal from the child to go for the visitation. She does not want to start her period with her father. She would like to go through that experience with her mother.
What the court is going to do, I am remanding you to the custody of the Calhoun County Sheriff, where you will remain until the child goes for parenting time. So however long that takes. So what you need to do is you need to make arrangements for the child to go with her father. And at that time, when the defendant confirms that the child is with him, then you will be able to be released from jail. That will be the order of the court, and you can go, ma'am, you can go with the sheriff, and hopefully you can get in touch with somebody to get the child turned over.